Can you put a sign on your door to say that TV licensing agents or anybody else is going to be fined £25,000 per visit in order to deter them from visiting? That is a question generally raised in the comments section. So welcome back to the channel. If you're new to me, I'm Daniel Shensmith, a barrister of England and Wales. I enjoy helping you to understand law, so please do bob that like button and subscribe if you find this content interesting. So today I found a rather interesting image on X, which was a notice that somebody put on the door, which I'm not going to put on screen because I don't want any copyright issues because I haven't sought permission and I don't have time to do so. But I can read you the general gist and discuss it because that is certainly not copyright infringement. The notice reads as follows, at least in the broad sense. It's a private property notice and it says entry is by invitation only and trespassers and damages will apply. But that's something we'll come back to in this video. It then says that the implied rights of access to the property have been removed. Fine, you've heard me talk about the removal of the implied right of access before. If you're not sure what that is, there is an implied right of anybody to access your property, i.e. come up to your front door, ring the doorbell if they've got genuine bona fide business with you. That implied right can be removed. Obviously, someone would need to come up to the door to read the notice to find out that that's happened. That might be important a bit later. Or you can write to them and tell them that this right has been removed, so they should know ahead of time. So far, so good. It then says, to all persons, corporations, councils, agents, there are vehicles manned or remotely operated. Because some people might have a remotely operated vehicle coming up to your front door. Who knows? But still, so far, so good. But then we go downhill a little bit because then it says that the performance of whatever it is, it doesn't really specify what performance is, but it talks about performance and says that it stipulates an obligation by way of a fee schedule. So it's suggesting that some fees are going to apply here. And then it goes even further downhill and it comes back to the beginning of this video and purports to levy a £25,000 penalty or 1,500 troy ounces of British silver coin per person, per vehicle, per offence, including the vehicles manned or remotely operated, etc. And Barraters fee schedules apply. Now, I'll come back to all of those later, but dealing first in turn with what we've just discussed. The removal of implied rights of access is perfectly fine. It is going to be trespass if someone continues to be on that land having had that right removed, but that is nonetheless, for the most part at least, a civil matter, not a criminal one, unless of course it becomes aggravated trespass where people committing criminal damage and that sort of thing. Or in certain cases such as the railway and Crown property, it might be a criminal offence from the outset. But the difficulty we come to here is where it purports that penalties apply for, it doesn't really say for what, just for being on the property without permission, I presume, but suggesting that a £25,000 penalty or 1,500 troy ounces of British silver coin per person, etc., will apply. And it refers to a Barrater's fee schedule. Now, the Barrater's fee schedule, it refers back to an old common law notion of Barratry, which was certainly not well reported until it was firmly abolished by the Criminal Law Act in 1967. But there's no real evidence that it ever made its way to any kind of criminal indictment. But as it stands, there is no current recognised standing for Barratry in English law. That's a polite way of saying it's meaningless. It originated to settle disputes and lawsuits and quarrels between people, but it's certainly not relevant today. As to the enforcement and any proposed legal action based on this sign, in short, it's not going anywhere. There is no court that is going to order somebody to pay £25,000 to visit a property when met with this sign, much less when it's put across as a fine or some kind of penalty. Now, there are also certain legal exemptions to private notices, which would include potentially postal workers, but certainly emergency services personnel, police in most circumstances, to allow them to access this property, irrespective of a private notice telling them not to do so. And so in a lot of those scenarios as well, the meaning of this sign, the enforceability of this sign would generally fall away. And moreover, coming back to the point of this being a fine, individuals have no authority and no jurisdiction with which to impose a fine on another person or indeed another corporation. Individuals in England and Wales do not have this authority to pose any kind of fine, whether it be for trespassing, for ignoring a private sign, or for any civil matters, or even for criminal matters for that matter. Individuals just don't have this power to levy a fine. It is reserved for governments, local authorities, judicial bodies, and not for private citizens or property owners. There is, of course, the mechanism for any such individual with any such sign to sue anybody that visits the door and they purport a breach of contract of sorts by visiting the property. But, as I said, that is not going anywhere in my view. Because even on a very basic level, for a contract to exist, there must be the minimum elements of a contract present. Thereby, there must be an offer of some sort, there must be evidence of acceptance of that offer, and there must be consideration. Everybody gets something. So, for example, if somebody owned a strip of land and they built it out as a car park and then they turned it into a publicly accessible car park and complied with any other laws and regulations that they might need to, they could then charge for people coming on that car park. And if it were managed properly and the management company was party to a trade association, they could then even enforce that parking and the contracts on that car park by way of parking charge notices. But there's still not a fine, because those are reserved and distinctly referred to differently as a penalty charge notice, and they are imposed and enforced by local authorities and anyone acting on their behalf. But fines and penalties, individuals and private companies certainly cannot impose on anybody else. But I thought that was an interesting bit of trivia for the day. It was the first thing that I saw when I popped my head out of work for the day. I thought it was quite an amusing read, especially with the comments and being tagged on it. So I will tag this video in that thread on X so that you can read back to it and see all the other comments left there. But more generally as to how this might apply to TV licensing agents or anybody like them, yes, on the one hand, you can remove the implied right of access for any such agents to visit your property, and they should comply with it. Much easier, I would suggest, just writing to them or filling in the declaration to tell them you don't need a license and they should leave you alone. Although I have had a number of emails to say that TV licensing do come back and say something has changed, even though it's not obvious to the people that have written to me what has changed or when. And so without knowing what and when something has changed, they obviously don't know what to do. So putting up a removal of implied right of access or sending them that by email might be one way to go. But the caveat that this comes along with is that if they do, for whatever reason, happen to have a warrant and come to your property to execute that warrant, usually accompanied by police officers, then you would, strictly speaking, be committing a separate offence if you do not provide reasonable assistance in the execution of that warrant. This is what the legislation provides. Now, doubtless I'll get keyboard warriors back again saying that I'm part of the system, I'm a barrister, and I'm employed by the government, I'm paid by the government, and all this sort of nonsense. It is nonsense, with respect, because I am completely independent. I am certainly not paid by the government to tell you any of this. I'm not paid by the government at all unless I do legal aid work, of which I do very little indeed, because of the nature of the work. So I am just telling you what the law is. That's what people come to a lawyer for. The law says that you will be committing an offence if you fail to provide reasonable assistance, as is your duty to do so, in the execution of a warrant under the Communications Act 2003. So that is the caveat. These notices on your door are not going to cut through any warrant or anything of that nature. Please do seek formal legal advice if you are unsure. And even when I say that, I get further keyboard warrior style comments saying, why am I doing videos if you can't rely on this as legal advice? Well, you aren't taking legal advice through YouTube, because I'm not sitting down with you asking you questions. I'm not instructed by you. There's no contract between us. Watch the comment section go crazy. Yes, so these videos are general guidance. So you must seek formal advice if you are unsure about anything in your personal situation. But I hope you found that interesting. If you do have questions about the implied right of access and all of the stuff that it might mean, Do check out my other videos on this channel. There's got to be over a couple of thousand videos on here by now. For those of you that might think I've done 50 or 60 or so, you can check out my library. There are thousands of them. So for that, I would be really grateful if you subscribe and like the video if you do find it vaguely interesting. And I will see you next time.